Yeah, we can start. Yeah, no. Yeah.
Okay. Hello, everyone. My name is Naveen, and I have graduated from NUSRL Ranchi. Then I started practicing at Jharkhand High Court for 2 years, and I got this opportunity after that to work as a law clerk. So currently, I am working as a law clerk at Center for Research and Planning at Supreme Court. Purvi.
Hi, good evening, everyone. So, I'm also associated with Center for Research and Planning at Supreme Court of India. I graduated from NLU Ranchi, and thereafter I completed my master's from Nalsar University of Law, Hyderabad. I'm hoping me and Naveen be of any help for you people. Yeah, sure. So, part one examination is an objective type examination consisting of 100 questions, which are allotted 2.5 hours, and there's a negative marking of 0.25 if you're attempting a wrong question. And this the whole part of 100 questions can be divided into three parts. For each, the first one is reading comprehension. It basically consists of excerpts from judgments or from any law book or a speech or like that, and they will be asking you a continuous 5 or 6 questions from the whole comprehension, that what you have analyzed from it. So for example, the question will be, what is the major argument of that particular paragraph, or what argument is antithesis to what you are actually getting from that comprehension, and or what exactly this kind of phrase means or a word means in that particular part. So it's mostly like how a reading comprehension that we used to do in schools is just it's more legal here, and we have to catch the correct argument and what is not the argument that you're getting from it. Okay. So the last year's examinations, there were 15 questions that were centered around this. Though there is no fixed number of questions that has been provided in the schemes, you can guess it around like 10 or 15 questions will be falling from this particular part. Second part is your MCQs from a substantive law. There are 6 laws that you have to be thorough with: Constitution of India, IPC, Indian Evidence Act, CRPC, CPC, and Contract Act. The questions will not be surely from a section specific. What I mean is that what is Section 32, Clause 8 of Indian Evidence Act? They're not asking direct questions from you. They're mostly to check your analysis skill. So they will be suppose given a fact-based question. They will give a situation out of you, and they will ask you, "Is this a murder? Or is this falling under any exception or not?" And there will be certain questions because you're not expected to rote learn all the provisions of different. Am I not audible? My voice is okay. I'll switch on the video if it helps. Okay. So I'll start with MCQ part again. So MCQs are basically from 6 substantive laws: Constitution of India, IPC, Indian Evidence Act, CPC and CRPC, and Contract Act. The questions will not be sections or subsection specific. They will not going to ask you directly what is the provision this of this particular section of Constitution or like. Okay, they'll ask you what you understand from it, that particular provision, or how you apply that provision to a particular set of facts that they give. For example, they will give you a fact-based question, and they ask to identify if there's a murder or not, or another question, or will it fall under any kind of exception, general exception, or exception of section in that particular provision, right? They can otherwise also ask you, suppose, what conceptual question, like they'll give you a provision and they'll ask you to identify the difference between robbery and dacoity. Likewise, that what is the difference between two different types of crimes. For CPC, what I remember is in the last year's examination, they gave a situation. They also provided the provision for it. So they're going, and this I think is also provided with a scheme also, that they will provide you with certain excerpt of relevant provision. So you don't need to actually rote learn. You have to understand. So even while you are going through your Bayer Acts, you have to get thorough with the concepts, that you're understanding that what murder is, what exception is, or otherwise in the Constitution also, what I suppose the basic eligibility criteria for president or vice president. You don't need to learn. You don't need to remember the exact provision or subsection of it. That helps. And the third part of the part one is the recent developments in law and jurisdiction. There were around 20 questions from it, and mostly they covered the recent judgments. If in this particular part, you can take help from the Supreme Court website. They have provided the list of 32 judgments, recent judgments. Go through them. Ideally, you should read it, but it's not a smart thing to do right now, that you go through, line by line all the judgment. Just understand what the judgment is about, what is the issue, how they have applied the law, what is the bone of contention, how court has justified it. So means know the crux of the case, the gist of the case. So if they are giving you an excerpt from it, or they are asking you directly, you know by reading the option that this is not possible, you can eliminate the options, or otherwise also you understand that which answer would be correct. And a very question you can accept what is happening in law recently. For example, last year, one of the question was, with what kind of cases are live streamed by Supreme Court of India? This does not come from a judgment directly, but this is a recent happening that you must be knowing about if you're reading, legal journal, legal journals like Live Law, Bar and Bench, and likewise. Okay. So there's some recent development that you should be aware of. You don't expect like a lot of questions from it, but at least 2 or 3. So give a reading to that also. Yeah. And how do you cover it? I would say start with the Bayer Act. Start with the Bayer Acts for all the 6 statutes. There are not so many. There are not so many statutes. So I think you will be able to cover it. Don't learn it. You don't need to remember word by word, provision by provision. Just understand the concept and how to apply that particular provision to a fact. They expect a lot of fact-based questions, okay, from the all kinds of statutes. And also, since the judgment list is supplied by the court, go through the gist of the case, the gist of those judgments. If you're not able to, go through the actual judgment exactly point by point. And thirdly, I would suggest that Supreme Court, publishes their chronicle. They've been doing this for like 3-4 months, last 3 months. For recent developments of what is happening in Supreme Court, you can just skim through it for the 3-4 issues that they are being published every month. So it will be helpful, I think. Aslan, you may continue.
Yes. So before you start making brief synopsis, you need to keep in mind that the judges had already gone through the whole file. So you just need, while making any case brief, you need to keep in mind key only the relevant facts and the principles needs to be mentioned. So while making this brief, you will be judged on 7 parameters. This has already been given on the notifications. So let me just jot down what are these parameters. First will be your ability to identify what are the relevant facts. There may be various facts which is very common to in every case, and which is not necessary to mention this before your lordship. So this ability will be judged. Second, your ability to identify the issues which has been raised before the high court or any appellate tribunals. uh, should I hello, is my voice audible, or should I switch off this? Okay. So okay. So for the third parameter, you will have to summarize this whole brief uh, into 2 pages. It should not be more than 2 pages, because what the question itself says that it should be brief. So we should keep in mind few things that we should not write. First is that we should not mention the exact extract of the sentence, exact writing of the judgments. These two things we have to keep in mind that we shouldn't write. And there is a proper structure that has been given while making this case brief. So first is that you have to mention the case number and the name of the party, which you can find on the first page of the whole case brief. And this, sorry, not the case brief, case files. So this case file will include the SLP or the criminal review petition, and apart from that, it will also include the appellate petition, and apart from that, it will also include the
I think it's Naveen voice that is breaking.
Give me a minute.
I think his internet is not working. Meanwhile, I can take up the question that Priya asked about do we look into BNS and other repealed acts? No, you don't, because the scheme mentioned about IPC, CRPC, and Indian Evidence Act. Otherwise, names would have changed. First thing. Second, they are not into effect yet, so you don't need to go there. But just you should know that there's a recent development in law that these acts have been introduced. Though the names of it, so there might be a one or if they do ask, they will just ask the name of the particular act that ever if it does comes. So provision is not being going to be asked about that. So don't read those acts. I would suggest you.
I have a question, but that is very general. May I ask? This is not regarding part one, but in general about the clerk. Yeah. So, I have heard that once somebody clears the written rounds, then they are to give a preference of the judges list that they would like to work with before the interview goes on. And so I'm also confused whether these, different centers of research now in the Supreme Court, they are a different functionality, and assisting the judge is a different functionality. I mean, when you are recruited as a law clerk, then what is the exact work that you will be holding, and how is it decided whether somebody would be assisting a judge or being in the research team?
Hi, Nabira. So actually, yeah, I'll take the question now. So when the list comes around, we'll be asked to give a preference for the judge. The first thing you give is that you are asked to give interview for the respective judges. So that is the first job. And if that doesn't fall through, or you otherwise don't want to, sit for that exam, registry calls for an application from the students that are left. Registry gives you an email that are you people willing to take up job for the registry, and then you give interviews for the registry. So the interviews will be completely different. First round is for the judges, they take up from the pool, and later on a registry takes up.
All right,
Nabira,
thank you. That answers
is
the
it
question.
fine?
Thank you. Yeah, thank you.
Sorry for this network. Okay, can you just tell me that what was the last line, what was the last thing that you guys heard? Okay, okay, just the first part. So, after you found the case name and the case number, you will have to write about the facts of the case. That should be written in maximum five sentence or a paragraph. You should, as I've already told you that the judges have already gone through all those files. You just need to mention that unique fact or important fact by reading which your lordship could easily recall that what case or which case you are talking about. Let me just switch off my camera. I think there is some audio problem. Yes. So you just need to write facts in one paragraph. Uh, then as for the next part, you need to write relevant findings which has been given in the impugned judgment. That is the judgment which has been challenged before the Supreme Court. So here you need to write what were the issues raised, what were the outcome, what were the ratio given by the judges. Then you have to go to the your petition where main grounds has been given, the grounds which you are challenging before the courts. So you have to only write the factual grounds, not the grounds which are related to any section or related to any case laws. Then you have to mention your prayer, which has already been given in the SLP. You just need to summarize that in one or two sentences. And in case there is an IA, IA could be for the condonation of delay or for any interim injunction. So you have to mention every separate IA again in one or two sentence. And if there is any counter affidavit or rejoinder, uh, you have to write only about those additional facts or issues or challenges that has been raised via counter affidavit or rejoinder. And there are very little chance that there may be any previous order. But in case if there is, you need not need to write any adjournment, any previous order where the petitioner or any party has sought for adjournment. You don't need to mention those. Only mention those previous order where the direction has been given by the courts. So this was for the first part where it is for case brief. Hmm. Okay, so as for the whole case files, first you will find your find previous orders which will be there. So that will not be considered an annexures. That will be your previous order. Then you will find case summary. From here, you can find your brief, your facts of the case, and the same facts can be found in the impugned order, which will be the first annexure of this petition. Okay, from this impugned order, you will have to take out issues, what was held, and what were the principle laid down, and what was the reason behind it. So impugned order is the most important annexure you need to go through. Then after that, there will be a annexure related to any documents or any certificates. Those might not be of any relevant unless it raises any particular concern. Like, let's just say if it is a matter of GST and there is one form, that, let's just say, form uh, a form under section 72. So those forms should be mentioned in one line, that a case has been challenging this particular show cause notice or this form under section this such and such. Apart from that, other annexures are not that important. You need to see that counter affidavit and rejoinders are there or not, and interlocutory application, because this is the again most important, because interlocutory application is majorly filed for the condonation of delay, which states that how much days or how many days there is a delay while filing this particular petition. So judge, there are times where judge need to know that how many days delays were there in order to adjudicate that particular case. So this has to be mentioned. Okay, as for this research memo, there is a cap of 500 to 750 words. Again, this should not be more than 2 pages, because the two things that on which we are judged is that how concise we are writing and what is the structure of our answer for both question number 1 and question number 2. So here, first thing, the things which will be given to us will be the facts, what is the dispute, and the statutes relevant sections will be provided to us, and some case laws will be given to us. Not all the case laws will be relevant to us. We need to understand that which we will pick and use for ourselves. So first thing which we need to write is the facts of the case, again in not more than five sentence. Then we have to frame an issue. Here issue will not be given. We have to ourselves, after reading the whole question, we have to figure out that what issue court will frame. So you need to frame that exact, or as close to as the court, as close to as what court will frame the issue. Then uh, then after that we have to mention the exact sections which are in disputes. That, let's say, if it is a case of negotiable instrument, section 138, then we have to mention that under one section, section 138, this particular case has been filed, and it has been filed because of dishonor of check or something like that, and for so many days we have to mention that. Then now here is the most important part. Here we have to use those relevant case laws. There may be 10 case laws or 8 case laws. You have to figure out then which case laws will be relevant for me. If I there Yes, I forgot one thing to say, that this question will consist a question which answer will be whose answer will be either positive or negative. There is no right answer for this. It is up to you and your analytical skill, your reasoning, that how structure and how much proper reasoning you give for your answer. You will be judged on that. So you have to pick up the proper cases and mention that how those are relevant, how by using those case laws you are coming to this particular conclusion. And there's this other thing, the case laws which has been given there but you think it is not relevant, you will also have to mention those cases that how it is not relevant, just in 1 or 2 sentences. So this is as for this research memo. And as you were saying that how should we practice for this? Best way would be that if you have access to any case files to any lawyer or any senior, that will be the most most easy and the most beneficial thing for you. So because reading take times. So the number of time you read new cases, new files, your reading time will automatically get increased, and you will understand that what facts are the relevant and what aren't. So one is this. Other you can do if you don't have access to any case files from any advocate or any pending cases, you can go through the case laws. Case laws will tell you that what case laws as for this judgment is written in SSC or in Manupatra, you will see that only the relevant facts are mentioned there, not the whole case. So these two areas are the thing I only two areas I think which will be helpful for this segment. Okay. This third segment, this is a new addition to this exam. So third question you will find five sub question or five position of law or preposition, and you have to choose any one and write answer to any one of this those prepositions. So as you guys might have gone through this notification where there is a sample questions, so you can see that majority of these questions are related to constitution. Even if there are questions which are not related to constitution, it is always better to write your answer or begin your answer with the reference to any article in the constitution, because every act is out or is based on this constitution. So it is our analytical skills that we will have to figure out that which particular article we can give or we can cite in this particular answer, and this should not be more than one page. So you don't have to write much in this answer, but you just need it tests your knowledge of law and your knowledge of precedent, that how much you know. There is very little to say about this particular question. Yes, that will be useful, and I will also suggest one more thing, that everyone should go through this any recurring topics or the landmark topics which has been going on for a year or two, and also for the constitution matters, you should go through all those major topics.
Sh- yeah, I think he's asking for part one. In part, if you ask general knowledge question, I don't know what your expanded meaning for it, but no, they don't. They're mostly from latest judgments and recent development of law. The judgments, the list of judgments that they have provided, go through those judgments. The questions will be from that, and read for any latest legal development that is going on from the legal journalism websites like Live Law, Bar and Bench SEC, or the Chronicle or Supreme Court. Otherwise, also, I would ask you what you exactly mean by general knowledge, if I'm understanding it correctly or not. Shrey, if you can answer. now. So after giving preference, after giving the preference list, you have to submit your CV to the registry. They'll ask for it. After that, your CV will be circulated to different judges, and as per your preference and your CV, judges will select few CVs and they will take interview. So the respective office will call you for interview. It's mostly online only. Otherwise, it depends on the judges also what methodology they use, but it's mostly online. Yeah.
Hi, Naveen. Yeah. Hi, Naveen Puri. Thank you so much. Like, I have two questions regarding the how the exam is conducted. Like, I was told by few present law clerks that they gave their first, I mean, they gave their exam in pen and paper mode, and like some other told that like they gave it on through computer based. Like, how, like, could you please clarify regarding this and like how few people did it? And the second question
I
is like what is this 30 minutes for reading? Okay, it was mentioned that like you will be giving 3.5 hours and 30 minutes for reading. And like does it mean that like they'll be giving completely 3.5 hours, or it's like first like they'll be giving the paper the question paper, and like after that they'll be, I mean, after 30 minutes will they be giving this answer sheet? And could you please tell like how was your experience?
Hi, I'll take up your first question. It was pen and paper test. It was not computer based. And for the second question, I think Naveen will have a better answer. But 30 minutes is for reading for the file because it's going to be huge for you to read and comprehend and analyze and write again. So 30 minutes is just for the reading, and for the rest of the 3 hours, you can frame or structure your answer and write. Is it right, Naveen?
Yes, as Parthu suggests that there will be a 3 hours and 30 minutes for this segment. So, first, this 30 minutes will be allotted to you, and here, what you will have to do is just to go through this question and figure out that what I need to write, what are the important things. And as for this question number three, there will be 5 questions. You will have to figure out that which one you will write. So, after this 30 minutes only, you will be given time to write right answer. Am I audible?
And could you, yeah. Like, could you tell about how was your experience? I mean, like, how was it pen and paper mode or the computer
Yes, it
based?
was pen and paper mode for
Yeah,
me too.
thank you so much.
Hi, thank you for this and thank you for organizing it. I just wanted to ask you guys if you had any thoughts on the kind of topics that can come for the third question in part two. It seems like they won't ask questions based on like pending cases or cases that have been recently decided, but they seem to be broader constitutional questions that are on, say, long standing debates on the constitution. So I was struggling to come up with questions to practice, and I was wondering if you guys had any suggestions on topics you think can come. Thank you.
Yes, I think that there will be a question related to constitution, and there is a high majority chance that out of five, two or three will be from constitution, and will be of very common topic. But what will be the exact that I cannot say.
Actually, I also want to add one thing that I don't think so. They're checking for your opinion that what do you think, what is right or wrong. They're going to check your analysis and your structures or writing skills. So, you need to be clear with what law you're using, how you're analyzing it, and how you're structuring your answer in the particular given limited time. So don't worry about that you're right or wrong. Your opinion. Okay.
Okay, thank you.
Yeah, so in part three, I guess there are options to choose, right? And each question is very extensive. So, how do you think we should approach part three in terms of uh, deciding which question to adopt? Should we like take those 30 minutes pertinently to to make that choice? Because multiple choice questions and part two questions we are anyway needed to do, but part three is where we have to make a choice and go with one.
Yes, for this question number three, uh, within those 30 minutes, you should decide that which one you should write, and it should be based on your knowledge that apart from all that from all this five, which one you think that you can assess more most uh, easily and in a more efficient way. So it is on your judgment.
All right. Yeah. There's another question that I have, sir. So, with regard to part one, multiple choice questions, legal current affairs. So, what happens is basically we have more than 100 case laws there, and it is practically not very easy to remember each case law along with the titular name. So, I am assuming that the questions so framed will typically ask us the reasoning behind those judgments and not simply in which case so and so was held.
Yeah, you're right about that. Also, there are more than 100 case laws, but Supreme Court has provided a list of 32 judgments that are relevant for this particular examination. You should be ideally going through all those 32. Okay? And they when they're asking about reasoning or your argument, you just have to know what the crux of that particular case is, what the issue was, how did they arrive at that particular, you know, result of that particular judgment. So this is not going to be directly कि this is the case what actually held was actually मतलब हुआ था उस केस में कि एक judgment दे दी and they 4 5 wide kind of options. But in any case, if you're going to the 32 judgments also, any kind such kind of question also comes up, I think it will be easy for you to do.
Yes, ma'am, got it. Thank you so much, both Naveen sir and Puri ma'am.
Yeah, I think there's a bar of like 40%. If you clear or 40 or 50% is provided in the scheme, if you clear that particular bar, your paper two will be checked based on that. But दोनों की for the rank list, I think the cumulative marks of both part one and part two is taken into consideration. So target that you attempt as many questions as you can. Obviously, taking into consideration that there is a negative marking. Don't target that this is a cutoff or something. Just try to attempt as many questions as you can. Also, negative marking is if you don't know anything about that question, do not attempt it.
Hi, I actually have two questions. I wanted to understand when you attempted the exam, was time management an issue for either of the two parts? That's my first question. And the second one is I wanted to understand what responsibilities you have if you're not working with a judge. If you're working in a center or something like that, what your main responsibilities would be.
Hi, Anvita. I think for part two, time management is very crucial because the reading part will be you will be given like a lengthy part of the file, and then you have to structure up, in your mind and in your paper like in 2 pages. So it does take time. So you have to be very mindful of that you decide that you are giving, particular hour, 1 hour first question, other hour for second question, but it completely depends on you, how much ease you are at that particular reading and particular topic which has been provided for the case file. Suppose if it's tax matter that it's been given, I don't think so they'll give, but if they do, I personally take a lot of time to read tax matters, and so I might allot a better chunk of my time to attempt that particular question. I hope you are understanding, right? That the question it totally depends on you that how much time you take for a particular question, but yeah, it's going to be difficult, so you be mindful of that.
Okay, yeah, thank you.
And second question you asked about responsibilities. I can tell. So there are different departments in registry. I can tell you about my department at CRP. So we have to do. You basically our main aim is for research and policy work. Whatever policy work that Supreme Court does, we do research and draft about on that. And otherwise, also if there is some public forum work that the judges do about speeches and forwards, we assist the judges with that also. Yeah.
Okay, thank you.
Yes, it will. It is always better to answer through a legal precedent if you remember at that time, or if you have knowledge about that particular law or precedent. So it is always better to use legal precedents.
Arslan, if I may take, there recurring question about rank and how many people attempted the examination. I think how many applicants were there, it doesn't matter actually that time also, this time also. And how do judges take up, students depending on the ranks of the exam. So there are 2-3 factors that comes into consideration. First, what is your preference? Second, your rank. And third, your CV. CV, I think it's most important. And based on that, just choose the candidate of particular CVs and call them for interview. And there is no prescribed number of people who are called for interview, first thing. And second, you actually don't take the rank as only the consideration, as far as I know. And it's a third thing, it is a confidential thing, so you never know. Yes, the question about that how many ranks in the exam provided posting with justices and all that. So it depends on your CV mostly, your preference, and then rank. So everything comes into the picture. Yes. So suppose if you're getting a call from a particular judge, first thing you do is get thorough with your CV, know what are questions are. So if your questions will be expected from your CV, that what you did before, a particular law, what did you do? If you have written a particular research paper, what was the idea behind it? And they'll ask you questions that also align with the work profile. So if they're asking, the work profile consists of research memos, making briefs or particular research work. So they'll, in general, there will be questions that have you worked with a lawyer before? So if you have prepared a research memo, what were your considerations? So it will match up. We'll try to match questions that suits their work profile also. And third thing, read about the judge in court. So that particular judge, why did you prefer that judge? I was asked this question that why have you given preference to this particular justice over other judges? So you have to have an idea that if I'm giving a preference of XZ judge, so what are his work areas and my work areas aligned with it? That kind of answer.
There is another
You
thing
can
which
also
we
go through their posters on the website, Supreme Court websites, to understand what kind of matters that the judge is actually dealing with, so that if you can expect questions from that particular area. Very basic questions, I would say, but yeah.
Yes, I would like to add another thing. There is this another thing that you need to keep in mind during interview, that they just want someone who is 100% willing to work and focus in this particular job, this particular work. So you have to portray yourself that this is the only thing that your major thing. There are notions that uh, there are notions that you need to some of them are preparing for this judicial aspirants are there. So if you say this before before your lordship, ki I also want to, I am preparing, I want to work here, and at the same time I want to prepare for my judiciary exam. So this will create a negative impact before your lordship, that that person might not be able to give 100% of his time. So we have to keep this in mind. Sorry, can you please repeat? I was unable to hear. For this, I would suggest that there are few case files on Supreme Court websites, case files. You can download any of them and try practicing. And other than this, you will have to read judgments. So from there, you will get ideas that which paragraph, because judgment is the impugn order. So any judgment of a high court is an impugn order before the Supreme Court. So from that you can analyze that this paragraph is not important. I can skip this part. Issues are given here, and where the issues are mentioned, where the conclusion are mentioned. So while reading all this judgment, you will get an idea that what are the things that I need to read and what are the things that I can skip.
Thank you so
Bye.
much.
Thank you. Bye.
Thank you, sir.
Thank you. Bye.